This is Jen Meyer with Parmele Law Firm, and we're visiting today with James Pavisian. How are you?
I'm well, thanks.
Good. James is our lead VA attorney, and he is going to talk with us today about a case that's made headlines. Go ahead and tell us the name.
Yeah, Bufkin versus McDonough.
What is this case about?
It's the benefit of the doubt standard. Let's talk about what the benefit of the doubt standard is.
Absolutely.
Essentially, the Veterans Administration jurisprudence is very unique in all of the United States Code because in most cases, the burden is on the person asking for the relief, and that burden is what's called probable cause or beyond a reasonable doubt. And essentially, the idea is that if you're filing for a benefit, you have the burden to prove you should prevail. VA is different. It's what's called the more likely than not standard, so 50-50. The way, if you like baseball, it's, tie goes to the runner. If there's a hit and the foot and the ball reach the base at the same time, the runner gets the benefit. And that's where the benefit of the doubt comes in, is when you realize that the evidence is really close and part of it is enough to deny, part of it is enough to approve. The benefit of the doubt starts, and anything that you're trying to decide needs to be in the favor of the veteran.
Let's go back and talk about some of the legal issues that were in this case. First of all, it was a standard of evidence. What does that mean?
Oftentimes in the life of a case, we'll have a veteran come and we'll file a claim. We'll submit some evidence. The VA will then order examinations. And if the examination matches with what we submit, then the claim is done, right? But then there are often times where the evidence conflicts. So we'll submit evidence that shows a veteran has PTSD and it's related to service. The VA will order an examination, and that the psychologist they sent the veteran to will say, no, there is no PTSD and it's not related to service. So we'll appeal it, and we'll go to the board, and we'll say, board, you have evidence on both sides. The benefit of the doubt applies in this case. And if you're going to apply it, then it goes in favor of the veteran. So you should go with our evidence. That's the standard of evidence. Like, how are you supposed to look at evidence and weigh it? Like when you put it on one side to the other, and then when you're looking at the weight of that evidence, how do you go? Does that make sense?
It does make sense. And ideally, whoever is making the decision would say, oh, you're right.
Or they say, you don't even have to say you're right. And this is where the benefit of the doubt comes in and why the case is important. All you have to get them to say is, you know what, it could go either way. And if that's where they land, that they're like, I'm not quite sure, then they need to decide the benefit is approved. That's what the benefit of the doubt standard is.
Due process. That is the second legal issue that was examined in this case. What does that mean?
So basically the process rights that the veterans have. In this particular case, the veterans were arguing, hey, my due process rights were violated because the VA was not applying this specific provision that Congress wrote. And not just the VA, but the Court of Appeals wasn't applying this particular provision. So what ended up happening with this case is the benefit of the doubt standard has been around for a long time. Congress got wind from advocates that the court was not applying the standard the way Congress intended. So what they did was they reiterated the law. They literally wrote a new law that says, look, we weren't kidding about this benefit of the doubt standard. Like, this is what it is, and this is how you need to apply it. And the courts still didn't do that. At least that's what they're arguing in Bufkin. And that's a due process issue because they're not getting the benefit of the process that Congress has told the courts and the VA to follow.
Okay. The next issue is the credibility of a testimony. What does that mean?
So in every case, you have a veteran saying, this is what I feel, this is what I went through, this is what my reality is. VA law, as I said, is very unique in that it starts with the assumption that the veteran is competent, and they use that word competent. Basically what it just means is they're going to believe you when you say something. They're going to start from that assumption that what you're saying is true. And that's what it means, credibility. So if you say, hey, I was in this theater of combat and I experienced this thing, even though they don't have photographic evidence of you being there experiencing what you did, they are supposed to believe that that happened unless there's evidence that really contradicts that, like you were never deployed to that area or that you weren't even serving at that time.
Okay. And what was the ruling in this case?
We don't know yet. They have not issued the ruling yet. Although listening to the oral arguments, this is a pretty conservative court. and they're very big on making sure Congress acts. And here, because Congress did act and was very explicit with what they want the VA to do and how to apply it, my assumption is it's going to be favorable to the veterans. It's going to come out in our favor.
But how is this going to affect veterans? What's going to change moving forward? Should this pass or be in our favor?
I don't know. That's the question, right? We thought a lot would change when Congress wrote the law again and said, this is what we want. My hope is that when Bufkin comes out, it's because they will get this decision from the Supreme Court. They'll go ahead and rewrite their instructions to claim processors. The board is going to obviously be retrained on it. And the question is going to be, well, how are they going to actually implement it? And when they implement it, are they going to do it in the right spirit? Are they going to actually give the benefit of the doubt? Or are they going to find ways to basically circumvent what the Supreme Court is asking them to do? My hope is that there's going to be more cases approved, that more of these judges are going to look at it and say, you know what, yeah, I don't know, and I'm just going to err on the side of the veteran like Congress wanted me to.
Obviously, stay tuned because we will talk once that decision comes out.
Yeah, that's going to be an exciting day.
That is going to be exciting. We will let you know what that decision looks like and how that may affect you as a veteran.
Yeah.
So thanks for explaining all this to us. We appreciate it.
No problem. I'm looking forward to that decision because, again, listening to the oral arguments, I'm pretty optimistic it's going to go our way.
We want to help veterans who need help with their disability claims. Something that we've really, I would say, ramped up on, isn't it? In the past 4 to 5 years, we have just seen exponential increase in the number of veterans that are contacting us saying, I need help. And we are sad that we have to do it, but we're thrilled that they're contacting us because we know that it is the right thing to do. As a veteran, served your time and given to us so much. And so we are honored that you would contact us to move forward with assistance on your disability claim. We have a specially trained VA team now, and that number has grown excitedly from a small group, 2 to 3 people, to almost 10 now. Is that right?
Yeah, and if you include the appellate department, it's even more.
Yes, we are ramped up. We are educated and aware, and we're ready to help you if you are a veteran and you've decided, I don't know what else to do. I don't know where else to turn.
Right.
So visit our website, and there is a link on there at the top of the page to the Veterans Disability section. The phone number is on there, and you will directly be connected to our VA team. And together, we'll just visit with you at no cost to determine what your next steps should be. We are excited to offer assistance to our veterans. We're thankful that they are contacting us, and I am anxious to hear the results of this case for sure.
Me too.
Great. Well, thanks for being with us today, James.
Yeah, no problem.
Thank you for being with us, and we will talk to you soon.